everyone, and welcome to this video tutorial in which we're looking at a possible exam question that could come up on vicarious liability in tort. And today we're looking at an evaluative type question where you're being asked to discuss whether the law on vicarious liability is fair on employers or not. And whichever exam board you're with, you're essentially being tested on two things here. You're being tested on A, whether you know the law, so whether you can explain facts, principles, cases, rules relating to vicarious liability, and two, whether you can analyse and evaluate whether that law is fair or not. And to make it easier, when I show you this suggested answer that I've got here, you can see that I've used different colours. So where I've used black font, this is where I'm explaining facts, so cases, facts, rules. Where you see red font, this is where I'm analysing and critically evaluating whether the law is fair or not. I'm highlighting where there are potential issues or problems with the law. And you can see that for ease, I've also highlighted case names just so that they stand out a little bit for you. In terms of structure, you'll see when I just scroll through quickly that generally there's a balance between black, red, and that's a little tip for you. When you're answering any evaluative question in law, you need to try to say what the law is and then, if possible, evaluate what you've just said, and that should then give you a nice balance of those two different assessment objectives that I've just explained. You'll have a balance of rules and a balance of evaluation, and that way you should maximise your chances of getting full marks. So let's take a look at some suggested content for this question then. Remember that if you're unsure about what the law on vicarious liability is, I do have a different video on my channel which goes through an overview of the law, of the cases on vicarious liability, and you could have a look at that before you start this one. So we always want to start with an introduction, and because this question is asking us about vicarious liability, it's nice to start with a definition of what vicarious liability is. So vicarious liability is where an employer is held liable for the torts of another, even though they didn't commit the act themselves. And it's a form of strict liability because our defendant, i.e. the employer, is not actually at fault. They didn't do the tort themselves, but they're being held responsible for what their employees have done. Straight away then, there's a criticism of this definition in that vicarious liability seems to go against basic legal principles, that we only in general impose liability on parties who are at fault or are blameworthy. But as you can see here, it's often justified by ensuring that those best placed to meet the costs of legal action, i.e. the people with the most money, take responsibility for the acts or omissions of those for whom they're responsible. They took him on, they've got the money, they should therefore put it right. So moving on then, we've defined it. I'm now going to go on to the rules for deciding whether vicarious liability applies. Now the fact that we've got two questions does make determining liability difficult, so that's in red because that's a small evaluative comment. So the first thing we have to decide is whether the person committing the tort was an employee, and the second question is whether they were acting in the course of employment when the tort was committed. And actually both of those tests, although they sound straightforward, have actually posed a lot of problems for the court, which we can see in the cases. So firstly, our claimant, that's what C stands for, must show that the employee has employee status. And the courts have developed a number of tests to establish this. And of course, as soon as you've got a number of different tests, that's going to make the law complex. So there's another little criticism we could make. And I'm going to go through and outline these tests. So the control test was the traditional test used to determine if someone was an employee or an independent contractor. And you could use Ewins and Noakes here. And it was held in that case that a person would be considered an employee if the employer had control over the work and was in a position to lay down how the tasks should be done. So it's sometimes known as the control test. However, you can see the date there, 1880, so a long time ago. This test has become less useful over time because the way that we work now is quite different to how it was in 1880. And because we've got increasingly skilled and specialised work, our employers don't necessarily have the same degree of control that they used to. So now it's only going to be one of the circumstances considered by the court. And in the case of Stevenson, Jordan and Harrison, it was held that the more the worker is integrated into the organisation, so they were looking at factors, things like, do they have a uniform? Do they have a staff room that they can use? The more they're integrated, the more likely they are to be employed. But you can tell from what I've just said that that's potentially quite subjective. Integration can be hard to determine then. What's been described as the modern test for determining an employee was established in ready-mix concrete, and I've outlined it here, the 3 conditions, and I've listed them. And a criticism we can, or it's not a criticism, an evaluative point we can make of it, is that on the face of it, that 3-step test appears very straightforward. You'd hope it's not going to cause too many issues. But in the case of Cox and the Ministry of Justice, we had a case where the prison service was held to be liable even though they didn't technically employ a prisoner in a kitchen. And in that case, it was held that the prison was still responsible because the relationship between the prisoner and the prison service was, and this is the words of the court, sufficiently close to an employment relationship. So you can see there the law really changing as time has moved on, sufficiently close. So an evaluative comment here is that this is showing that the traditional tests of employment have proved to be too narrow in recent cases, and that the courts are now adopting a more flexible approach to finding an employment relationship. But you could argue that this may be unfair on employers because we're stretching the law in a way to find liability. But on the other side, and it's always nice to give balance, others would argue that employees are working for the benefit of the employer, who should take responsibility. So in that case of Cox, the prisoner was doing a job that was of a benefit to the prison, so why shouldn't they take responsibility for the actions? The next little critique is that distinguishing between contracts of employment and contracts for services is difficult, and you can use lots of recent cases on this. There's some on Uber that would be really interesting to talk about here. So in recent times, the nature of employment has changed, with workers far more insecure than in the past. They may be employed on a casual basis, via an employment agency, on a government scheme. And in all of these situations, it may be difficult to ascertain whether they qualify as what the courts would view as an employee. And you could make the comment there, linking back to the question, that it's arguably unfair on an employer if they can't predict whether the person that they're paying to do some work is going to be classed as an employee or not. And this difficulty is compounded by different arrangements that are used to limit tax liability. Often people will be labelled as independent contractors, for this purpose. And so the courts face a real challenge in distinguishing between those 2 different types of contracts. The next rule that we need to look at is that the employer is only going to be liable for the torts committed in the course of their employment. And that means conduct authorised by the employer or it's closely connected to the job. Little criticism here. Some may say that that diminishes the deterrent effect of tort law because employees might question whether they should take care at work if any harm is paid for by the employer. Century Insurance in Northern Ireland's a nice case to talk about here, and this, if you recall, was where an employee was delivering petrol and he actually lit a match to smoke a cigarette at a petrol station caused an explosion, and it was held that the employer was still vicariously liable because the employee was doing his job in a negligent way. Now I should really, have put a criticism there to say that might actually seem quite harsh for the employer, because the employer obviously wouldn't have wanted this person to be smoking a cigarette in a petrol station. That was an incredibly negligent thing to do, but the employer, was still vicariously liable. So it does seem unfair in some cases. I've then gone on to Story and Ashton, where it was held that an employer wouldn't be liable if the employee was on, quote, a frolic of his own. And there can be difficulty in deciding whether an employee is on a frolic of his own or not, which can lead to inconsistent decisions. And you could compare and contrast the cases of Limpus and Iqbal on that. A further problem, which might seem quite unfair for the employer, is that there's uncertainty in the law if the employee has caused an accident whilst travelling to work. And we've got a whole host of cases here listed that have clarified the issue from journeys. So the rule now is that travelling to work is not in the course of employment, travelling between workplaces is in the course of employment, derivation from journey is not in the course of employment. And again, I've not done it here, but I could have put another red sentence after that. Hopefully it's jumped into your mind, that if we've got all these different rules on travelling, again, that's making the law complicated, and the employer potentially doesn't really know where they stand on that. Another issue is that the law's controversial where the employee has done an unlawful act, so they've done something criminal while at work, and the issue is that classed as being in the course of their employment. So Lister and Helsey Hall, the defendants were liable where the employees had sexually abused a number of children. And then we could look at Catholic Child Welfare Society, where the Supreme Court found that the institute could be vicariously liable for sexual abuse by staff at a school. And Lord Phillips said that there was a close connection between the abuse and the relationship between the staff and the institute. And I've used some of his wording here. He said it was because paradoxically they were doing what they had set out not to do. And a critique of this is that some people would say that these decisions are inconsistent with retributive justice, because it does seem wrong that a person's found liable in tort when they themselves have done nothing wrong, and the employers clearly did not want their employees to be doing these unlawful acts. So reaching a conclusion now, but there is quite a lot of evaluative points that you could sum up here with. So we want to link back to the question. In conclusion, the law on vicarious liability seems harsh on the employer because they're liable in tort despite not having done anything wrong themselves. And we can make the point here that the courts now take a much more flexible approach to the employer-employee relationship, which means that employers are now potentially liable in situations where they wouldn't have been in the past. And Cox is a nice example of that. But such liability is often justified on the basis that the master has the deepest pockets, which is what we said at the beginning, that the employer is often in the position to pay for any legal action. They make a profit from the activities of their employees and therefore should bear any losses. And I've included a nice quote from Glanville Williams that you could use there. And this is making sure that the claimant is able to get their losses covered via compulsory employer insurance. And employers do have the ability to spread the cost of insurance through the price of their goods, controlling other fixed costs, adjusting wages. And the employee's activity is likely to be part of the employer's business activity, and so the employer has created the risk of the tort. And it's reasonable that an employer who appoints an unskilled or careless person, such as Homer Simpson in the picture at the top, should be responsible for their actions. and that it encourages accident prevention, potentially, by giving an employer a financial interest in encouraging his employees to take care for the safety of others. I hope that you found that useful.